NACDL is the association of the nation's criminal defense bar.
Welcome again to NACDL's 19th Annual State Criminal Justice Network Conference. So this is, as the last panel kind of started to get into a conversation on policing, this panel is going to get into that a lot more. So the panel title is Policing in America, Policing the Police. It's going to be talking about police accountability and transparency. And I'm going to turn it over to our moderator for this panel, which is Norman Reimer. He serves as the Executive Director for NACDL. So take it away, Norman.
Good afternoon, and thanks very much, Monica. For those of you who are either working in the nation's criminal legal system or advocating to reform it, this is the panel for you. For those of you who want to focus on the single most important reform to promote accountability and transparency and to improve and professionalize policing in this country, this is the panel for you. And for those who want to take steps both in policy and practice to minimize police abuse and wrongful conviction, you guessed it, this is the panel for you. This panel is about a place where policy and practice intersect. And when that happens, the prospect for achieving a more just system explode exponentially. I'm really excited about this because where policy can elevate practice and practice can result in reform, that's where I, as a defense lawyer and a reformer, want to be. Before we get into the topic, I do want to step out of my moderator role for just a moment and step into my role as NACDL's Executive Director. Thank those of you from all over the country for joining us for our 19th Annual State Criminal Justice Network Conference. It is, in fact, our first virtual conference, and I fervently hope that it will be our first and last, and that we'll be able to get together for our 20th conference next year in person. I'm so glad that so many reformers and so many NACDL affiliates and partners and collaborators are participating in the program. I also want to express my tremendous gratitude and admiration for NACDL's Advocacy Director, Monica Reed, and to Nora Zimmerman, as well as so many of our colleagues on the staff for their tremendous efforts to orchestrate this conference. If you think this program is valuable and you're a lawyer, please join NACDL. And whether or not you're a lawyer, please consider supporting the NACDL Foundation for Criminal Justice, which makes so much of our work and programs like this possible. Now let's dive into it. In about half the states in the country, police misconduct records are secret by law. In many other places, they're secret because of collective bargaining agreements. In some places, it's both. But why does this matter? It matters because when you arm people and you give them license to stop, to frisk, to forcibly arrest, to barge into homes and businesses, to search and seize, there can be no fairness, no justice, and no accuracy when prior patterns of misconduct are kept secret. And they are kept secret all too often and from far too many. They're kept secret from those who are arrested, assaulted, searched, or seized. They're kept secret from defense lawyers who defend those who are arrested, deprived of vital relevant information. And they're kept secret from prosecutors who decide what charges to bring, what bail to seek, what evidence to use, and what sentences to pursue. And they are also kept secret from the judges and the jurors who must decide whether to believe a police witness, often the most critical witness in a criminal case. And of course, these records are kept secret from the public. And we know, as a matter of irrefutable fact, that hidden police misconduct is a factor in wrongful conviction, and it is a factor in police assaults and killings. We also know something else. We know that having access to prior acts of misconduct can improve the quality of justice, and it can promote a cycle of reform. And we have the two panelists here who will bear witness to this truth. Our panelists are on the cutting edge of promoting a fundamental reform in both policy and practice when it comes to policing in this country. First, we have Rebecca Brown, who is the policy director for the Innocence Project, where she directs the Innocence Project's federal and state policy reform agenda. She and her team have successfully helped pass more than 200 state reforms. Rebecca is actively seeking to repeal police misconduct secrecy laws around the country. And just a few months ago, Rebecca was a key partner working to support community-based reform groups to repeal one of the most restrictive laws in the nation, New York's Section 50A. Ironically, a section of the civil rights law, which made it virtually impossible to get police misconduct records in most cases. That law is now gone. Rebecca will tell us how that happened and how it can happen elsewhere. We also have Julie Ciccolini, who is a research technologist at Human Rights Watch and part of the Digital Investigations Lab, applying technology to support Human Rights Watch investigations. But importantly, before that, Julie worked for the Legal Aid Society in New York, where she designed and managed the Cop Accountability Project, a database that identifies and tracks patterns of police misconduct in New York City. Julie has begun working with defender groups across the country to develop databases elsewhere, and our organization, NACDL, has obtained a license from the Legal Aid Society to use that platform that Julie developed to support national implementation of similar defender databases tracking police misconduct. So let's get to our conversation. And I want to start off, Rebecca, with you. And I want to ask you, what evidence exists to prove that there is any nexus between police misconduct and wrongful conviction?
Sure. Well, thank you, first of all, for having me today. It's a real honor and pleasure to join you all today. And, at the Innocence Project, we are unsurprisingly seeing connections between police misconduct on the streets and wrongful conviction. Consider John Burge. He's a Chicago detective, area commander, who, along with his subordinates, who were known as the Midnight Crew, Burge's ass kickers, and the A-Team, that crew, Burge and his team, coerced countless confessions, many of them false, from suspects through beatings, suffocations, mock executions at gunpoint, sexual assault, and the use of electroshock machines on suspects' genitals, gums, fingers, and earlobes. And they directly participated in or approved the torture of at least 118 Chicagoans, most of whom were Black. And through these abusive tactics, Burge and his officers contributed to countless wrongful convictions as well. Many have been overturned, some are still pending. This has led the city of Chicago to pay out nearly $60 million so far to survivors of his abuse. Yet because of exemptions written into Illinois' Freedom of Information Act, the disciplinary records of some of the Midnight Crew officers are still being withheld from the public to this day. These cases are the tip of the iceberg. We've uncovered similar cases from Philadelphia to Kansas City to Louisville. And of course, the racial implications and dimensions of this are undeniable. Many of the cops who committed official misconduct in our cases were cops with histories of abuse, including excessive force against communities of color. So, certainly we are seeing clear connections between brutality on the streets and wrongful convictions.
So let me ask you this. If a defense lawyer does not have access to the misconduct records and the witness and the police witness testifies, aren't we depriving the public, let alone the accused and the courts, of vital information?
I mean, absolutely. There's no question. And I mean, for all of the reasons that you mentioned in your introduction too. I mean, this impacts the entire system. Even when it's shielded from prosecutors, that influences the charges they're going to bring. It certainly can have an impact on discovery practices. For all of these reasons, this information is key. It's key impeachment evidence, and it's not in the hands of the defense.
I want to come back to the trial and the litigation ramifications of having these things kept secret. But I want to shift just for one moment and talk about the role of secrecy in allowing cops who are ultimately capable of doing great damage to people to remain on the force. In the tragic deaths of Eric Garner in New York, in the George Floyd case more recently in Minneapolis, we learned that the police involved had long misconduct records. Is there any reason to believe, we often hear, well, this is a bad apple. Are those isolated cases, you think, Rebecca?
No, I think absolutely not. They're just hidden cases. And, the nation's high profile cases paint a terrifying picture with respect to the secretive nature of these disciplinary histories being, kept secret. Sometimes this is because, as you mentioned in your intro, that records are destroyed under union contracts. The disciplinary history, for instance, of the Chicago cop who fatally killed Laquan McDonald had been deleted under the department's contract. Other times, the misconduct histories remain hidden because of what we've been talking about today, or what we're talking about today, which are really these laws that enable them to remain hidden and ever seeing the light of day. I mean, Daniel Pantaleo of the NYPD, who choked Eric Garner to death, had been the subject of more than a dozen complaints. His history had lived in a black box. It was protected by 50A, the law that, of course, has since been repealed. And, the grand jury declined to indict him. And the public learned about the 14 prior complaints against him 3 years after Eric Garner died. And that was thanks to a leak. So, I mean, again, this would have remained just a total secret. A leak wasn't necessary to expose the disciplinary history of Derek Chauvin, in the George Floyd case. The public quickly learned about Chauvin's disciplinary history. At least, I think it was 17 or 18 complaints that had been leveled against him over 2 decades. And that record was made public by the Minneapolis Police Department because Minnesota is a state where police disciplinary records are made public. So yes, I don't think this is the tip of the iceberg. These cases, when they come out, I mean, it's obviously, of no surprise to anyone that, there are prior histories, but I think this is not, this can't be seen as a bad apple kind of situation. This is clearly systemic. And obviously, if it was a bad apple situation or, one-off situations, we wouldn't see the overwhelming opposition when it comes to repealing these laws.
So how do these laws get on the books in the first place? And how do they stay there?
Right. Well, I mean, I think, certainly for those of us that are working in state houses around the country, the power of the police union is undeniable. And they are very influential with lawmakers. They are able to, I think in many instances, sort of, dress this up as a reform, or a need or a protection that law enforcement requires to do their jobs as public officials, that they're somehow, protecting even complainants in having laws on the books like this. And this extends past secrecy laws, the Law Enforcement Bill of Rights laws, which also add to the problem. So this is a multi-layered problem. I think the secrecy laws are foundational in terms of what we need to reform, but there are so many other aspects of this issue that we have to address if we want true police accountability.
Very often when these secret misconduct things tend to surface, it's after there's been a wrongful conviction, perhaps after somebody spent many years in prison, or after a horrible custodial death, which just happens to have been filmed independently.
Yeah.
But what does that suggest to us? Those are fairly rare situations. I mean, brutality short of the kind of thing that happened to George Floyd happens, I would assume, with a much greater degree of regularity than people think. Same thing with wrongful conviction. We can't know about most of them, right?
That's exactly right. And I think, even in the course of dealing, when our clients, once they're exonerated, are often, seeking civil redress. And when civil lawyers go back and, look into the records of the police in their wrongful conviction case, they often find a litany of complaints, and oftentimes too, a litany of unfounded complaints or unsubstantiated complaints. So these are, we have to pay attention to those, because when we go back and reinvestigate them, the civil lawyers do, they find that in fact, they were meritorious.
I'm going to drill down on that, I think, in our next segment, but right now, I want to ask you about something. I know you've written about it, and I first heard this term maybe more than 20 years ago when a commission was investigating police misconduct in New York. What is testifying, and how would the release of these records help to minimize it?
Right. That's so testifying is, when law enforcement are on the stand and providing untruthful testimony. What's problematic is, even when it comes to the secrecy laws, really making sure that that information sees the light of day. And unfortunately, for you to access that information, even in a state that makes records transparent, there needs to have been an investigation initiated. And I really am so excited to talk to the defense community today, because that's really where the defense comes in. I think in most instances, unless there's sort of like a judicial finding of, test-lying or perjury, there's no record of it. And so it really is incumbent on the defense community, I think, to make these complaints when they learn about test-lying in their cases, because it will certainly implicate cases to come. But it's unless somebody's making a record of this, either through an investigation or unless there's a judicial finding, that probably will be absent from the disciplinary record of the cop. So again, this is a real, I think, incentive for the defense community to get active in this area to make sure that those allegations exist, even if they've never been adjudicated. They're just on the record.
So before we transition over to Julie and talk about how practice can propel reform, I want to just take you through a little sequence and see if you can help explain something to all, particularly the reformers out there. Is it fair to say that if misconduct is known, that it decreases the likelihood that the witness, the police witness, will be believed? And if it's less likely that the witness will be believed, it makes it more likely that the witness will not be used. And I guess my question is, wouldn't the disclosure of this force police departments to reform and propel the reform movement generally?
I think
explain why.
Yeah, I mean, I think there's absolutely no question of that. I mean, I think, we already know that prosecutors keep Brady lists of, and, they are aware of certain cops. I mean, certainly this would influence even charging decisions. But I think, when it comes to just being able to use cops, at trial, I mean, there's a clear disincentive to do that. And then, when this becomes a pattern and enough of these, emerge as examples, and I expect there would be plenty of them, that's going to force a culture change in the police department. They're going to have to, make huge changes so that, cops can actually testify in cases. So yes, I think the sequence that critically important, and that has to happen.
So that sets the table perfectly for us to transition here a bit, to take a look at how exposing police misconduct can actually elevate practice and lead to more reform. Julie, you implemented the cop accountability database in New York, and you did it while we had this strict secrecy laws. You did it, 50A was just recently repealed, and yet even without access to formal records of misconduct, you proved that aggregating other police data not only improved outcomes in the courtroom, but also helped fuel reform. So let's start at the beginning. How did the project come about, and how do the lawyers actually use it in practice?
Great. Hi, everyone. Thanks, Norm. So the project came about out of the need to be able to obtain any information we could about police misconduct, because we couldn't get it through any official records. New York had one of the most restrictive laws, 50A. And so without our attorneys, even on cases, being able to look at what a cop had done wrong before, we wanted to see what information we could access through open source methods. And so let me throw up a slide real quick, just so that everyone can see, of kind of the different sources of where we looked to find police misconduct data. Because not only is the problem of not getting official records an issue, but it also is that these official records are only what the police departments determine are misconduct, right? And we know that police misconduct comes out in various different sources. And so I created a database, and we started tracking what we could through public means. And that was civil rights lawsuits that were filed, federally through our state court websites. We had relationships with the civil rights attorneys in our jurisdiction, and so that we were aware of any cases being filed relating to police misconduct. And even media reports, it would be that simple, where an officer could be so far as arrested or accused of severe brutality, and it was coming out in the news, but nothing was happening behind the scenes. Anything we could get through freedom of information requests, their police overtime, which actually has been shown to be correlated with police misconduct, declined prosecution data.
Let me just jump in for 1 second. Explain why the overtime data is often an indicia of potential misconduct.
Sure. So officers can get overtime for either making an arrest, usually at the end of their shift, and so they have to stay later to fill out paperwork. Sometimes they may switch arrests with a different officer so that they can, the court date is on their off day. And so if they show up, they'll get overtime. And so now they're kind of claiming to know about an arrest that they might not have even been the one who saw what's in the complaint. And so we've noticed that officers make very sometimes weak arrests, kind of broken windows type policing arrests towards the end of their shift in order to earn that overtime. And we did calculations on the number of lawsuits officers had and the amount of overtime they learned, and saw it was a pretty clear positive correlation. So it's not.
Thanks for that clarification.
Yeah. And then other data we could get to the public, sometimes there's a few sites where civilians can file complaints that don't go directly to the official administrative system. And we're able to see that public reporting. And then judicial decisions for like incredibility findings or evidence suppression that would show up on Westlaw and Bloomberg. And so we started kind of scraping and downloading all of that and throwing it into a database. And at the same time, asking our lawyers to look out for more information that's happening in their cases, right? Because again, not everything is going to end up in the police department internal affairs. They weren't tracking even judicial findings of incredibility. That was something that we knew we wanted to track. So even just notes from our attorneys sometimes could reveal increasing patterns of misconduct of this client, this team of officers entered this client's home. They said they didn't have a warrant, but busted down the door. And we'd see note after note from an attorney about the same group of officers.
Julie, let me just jump in because I want you to point out to the viewers something that was really unique, the unique opportunity that the Legal Aid Society had, because the Legal Aid Society operates in all 5 counties, all 5 boroughs of New York City. But the police had a practice of moving cops around, right?
Yeah. And so, exactly, prosecutors under Brady would have to disclose certain data that they knew about an officer's prior misconduct, but they had to be very well aware that it was happening. And if that officer moved from their court in Queens to the Bronx, then that new prosecutor wasn't aware of their past misconduct and therefore didn't disclose it. And so officers in New York would frequently be switched around once they kind of got a history in a certain borough. And we were able to tackle that because luckily we were operating in all 5 boroughs and worked with the other defense organizations in those boroughs, so that anytime anything would be disclosed, we would track that. And if that officer moved, we still had it in our file on them. And so all of this, and then another big portion was we were tracking the arresting officer on every case that we had. And that actually illuminated a lot of patterns where we could see what types of arrests an officer was making, if a bunch of felony gun charges were being dismissed. And so we could analyze and identify kind of different suspicious patterns happening through there. And all that data helped us get a subpoena for the actual disciplinary records. And so this database almost existed just so that we could write what's in New York called the Gissendaner motion to request the official records. And there's a very high standard for getting that approved of you have to kind of cite that this officer has a history of misconduct that's related to your theory of misconduct in the current case without knowing what is in that officer's file already. And so this definitely helped us do that. And so we turned this database into a web application that our attorneys could just have on their phone. And so this is the
I want you to talk about how incredibly useful this was and how lawyers were actually able to use it in real time in the courtroom.
Right. Yeah. So this was the first iteration of our database, and it was a web application. So during arraignments, they were able to pull it up on their phone and just search for the officer's last name, and out would pop up everything that we knew about that cop. And we saw this make a huge difference at almost every stage of the case. In certain instances, there would be a DA requesting extremely high bail or no bail at all. And then our attorney was able to stand up and say, well, this officer, has 10 lawsuits before for unlawful searches. In this case, involved a street search. And all of a sudden that client would be released. It helped even at trial, where we heard specifically from jurors that the information that we had in this database that was used to cross-examine the officer was the reason the jury didn't trust that officer anymore, and returned a not guilty verdict. DAs would sometimes outright just dismiss cases because either they knew this was the only officer who could testify and they didn't want all of this coming out on the record, or they didn't want to disclose any more information about that cop. And so as soon as we, submitted our Gist and Danner motion and it would be time for them to hand over their disciplinary file, the case would disappear. And so this became almost a standard part of our practice, is attorneys almost on every case would look up who the officer was and just see what was in the file. And there were even certain just names of officers that became, notorious in arraignments. If you pick up the case with this cop, look him up, because he's been found incredible 5 times before, and his testimony should never be trusted.
It's incredible to think what you were able to do just by harvesting this public data and the data that your own lawyers were gathering, and it does make you think if the records really were, if the actual misconduct records were available, you can just see what an impact it would have.
Mm-hmm. Yeah, I mean, I think as soon as we get our hands on these real 50A records, it'll be a huge change for us, because like I said, the amount we've been able to discover without those, and the misconduct and the themes we've seen have already made such a turning point for our cases. Once we have all of these official records, and again, put them in this application that attorneys will be able to easily use and look up, it just becomes a standard part of a case.
So do you have other slides that to show how the data appears?
So this is our public website. So after we created our internal database, which included what we called that work product information, which was stuff that we didn't actually aggregate from public sources, we pushed out a public website, which just was the data that already existed out there, kind of regurgitated in a format that was easily accessible. And so that was catchstat.nyc. And here you can kind of see an example of it in officers' profile, where we have who they are, their overtime, lawsuits against them, and some known disciplinary cases that they've involved in. And then we also kind of aggregated this data by the precinct and commands, because we noticed that officers often routinely engaged in misconduct in teams. And sometimes it wasn't just this one bad apple cop, but this one precinct with, a commanding officer, or even maybe at a higher level where their directives were specifically to violate civil rights. And so we wanted to look at this in more of an aggregate manner. And here you can see how we started to make even associations between officers. So I know on the left, it kind of looks just like a big blob, but this is actually kind of an algorithm that puts the pinpoints closer together, which are officers, depending on how closely they are related. And so the size is how many times they've been sued. And so you can actually see here that we knew the 75th precinct, which is the biggest little bubble, had the most lawsuits, and these officers who are close together, those little dots, have been sued frequently together. And it helped us identify these teams of officers working together. And I think so.
Yeah,
after
this is I was hoping you would get to this. This is what's so amazing about how changing the practice, making this tool available, then leads to what you're about to tell us.
Right. And so after we came out with this, the district attorney all the prosecutors started getting caught off guard by our attorneys, because we knew a lot more about that officer's misconduct than they did. And, they have an obligation to disclose it, and they weren't able to fulfill that obligation. But because we were tracking that officer's findings, we would be implementing this information in a case that they weren't even aware of. And so the DA in Manhattan actually went and wrote a letter to the NYPD saying that they needed to turn over more information about police officers so that the prosecutors knew when they were assessing a case, and to fill that obligation. And so it created what we're calling this virtuous cycle, which was, because we had this database, our attorneys are using this information in court. The DAs, just by the nature of how it works, had to create their own to fulfill their obligation. And, you know, we keep pushing out this police misconduct data in the media and make sure all parties and all the public defenders have access to our database. Everything we can share publicly, we share. The prosecutors are continually pressured to disclose it, which is more information that we can just keep adding back to our database. And so it creates this virtuous cycle where everyone kind of has to be fulfill this obligation, right? Be on guard to disclose to one another.
So why don't you talk a little bit about plans to try to take this on the road, as it were?
Yeah. So very exciting is, after we did our first initial version of the database in New York, it went through a lot of phases and bulked up, and I spent the last couple of years redeveloping it to make it so that it could work in any jurisdiction. And so designed an application at Legal Aid to track police misconduct, and hoping that it can be installed in any public defender's office and they'll be able to use it. So it's not just specific to whatever data you want to track. And so it's like a cloud-based application, which means it works on a phone, on a tablet, on a computer. Multiple organizations will be able to use it. So in New York, which was kind of vital to make this work, we have 5 different defense offices. And I think 12 organizations that kind of, like, including the Innocence Project, who could use this information. And so we share portions of our database with them, but are able to still keep our confidential work product information to only like the legal aid eyes only. And so as much as possible, all the defenders and, you know, other organizations would share what they can with each other. And then any information they're tracking, like those confidential case notes, they still put in the database, but only their organization is able to view them. But that allows us to track these officers no matter where they go. And like I said, it was kind of generalized so that it can handle any type of misconduct data, because in New York, we never got official records. And so we're tracking all of these, you know, it's like 15 different, I would say, categories of data. But in other jurisdictions, you may have access to different sources, or maybe you do get access to the police disciplinary files. And so it's flexible enough that you'll be able to implement that. And so I don't want to dive too deep into all of the features of the database, but you know, this is what our officer profile looks like. So this is the officer who killed Eric Garner, and you can see kind of on the left we have his face, his identifying information. On the right, kind of his history of misconduct. And so not only are we now tracking the lawsuits, internal investigations, but we tag these summaries for kind of the civil rights and human rights abuses that are happening in them, which allows us to analyze this data on a larger scale. So even though this is a single officer profile, when we're tracking all of this misconduct, we can look at it from what's happening even in the 75th precinct or the NYPD and do comparisons. And hopefully, once we have these databases in more locations, do national level comparisons.
Well, it's truly extraordinary. Yeah, look, yeah, you know, I see you've got the whole incident summarized. That's fantastic.
Yeah. And so, Norm, should I go into kind of our larger plan?
Yeah, I would just a little bit give a bit of an overview, because hopefully, you know, eventually, not just through what we're doing, but hopefully this will be something that will be standard practice throughout the country, and ultimately lead to breaking down the secrecy and professionalizing policing, which is what, you know, I think we want, professionalizing.
Yeah. So really excited. Hopefully come September, in a couple of weeks, I'll be joining NACDL, and we'll be kicking off our law enforcement accountability database project, which will involve taking the system that we created. Legal Aid has given NACDL a license to license it elsewhere, and helping public defender offices stand it up. And so that means helping you implement it, and then helping you figure out what the sources of misconduct are in your jurisdiction, what laws maybe are blocking you from getting access to those records, when we'll call Rebecca and ask her to help us out. And as much information as we can, help you set up a database so that you can start tracking police misconduct in your office. And so the plan is to go a bit office by office and take this, one place at a time, but to do really what we did in New York, which is capitalize on any information that's available in that jurisdiction and use it as pressure to change laws that maybe don't allow all of the information to come out. And as much as we can, hope to push what's happening in this database public through the media, with journalists, study it with academics, and really make this case for what's happening in policing.
Well, thanks, Julie. I want to, before we open it up for questions, Rebecca, I want to go back to you now that we've seen how the change in practice actually not only benefited people, but also started to promote reform. And I want to get into the reform of the law in New York as an example for others elsewhere. But I want to start by asking you, how helpful was it that you actually had DAs asking to have these laws repealed? And I think eventually the police commissioner in New York, right?
Right. Well, I know that some prosecutors came out, and I mean, for sure that buoyed the effort. There's no question about that. Obviously, when all corners of the criminal justice community are asking for the same reform, it's much easier to get something through. But I think, the real story here was the power of the grassroots and the Communities United for Police Reform, which was, a movement of community members, many of whom were personally impacted, who had even had children who had been killed by police. Lawyers, researchers, activists. So it was sort of an umbrella campaign that, brought all of us in, but just incredible effort by them. They worked at this for almost a decade. And, it really was sort of this moment, right, where everybody was paying attention, that made this inflection point. It became an inflection point, but really had their groundwork not happened, had this not been, just an outcry for years and years, I don't think this would have passed. So I think there were so many factors. I think the prosecutors were, obviously very helpful too when they came out on this.
Yeah, I think that you make a really great point, that the groundwork has to be laid, and it may seem like it's not going to happen. I know that many of us were skeptical that it would happen in New York, but then this horrible moment happened, and there was all this energy and all the groundwork that was laid by these community groups, supported by other advocates. And that really, I guess, is what put it over the line. What do you say to the arguments that, reformers will have to, they'll have to deal with unions, police unions, and other champions of law enforcement? What do you say to those who say, well, this is really an invasion of privacy? These people are putting their lives on the line to go out there and protect the public. They shouldn't have to have their misconduct available for people for everybody to see. What do you say to that?
Right. Well, this was certainly something that came up with 50A. There were a number of protections that were written into the law and that can be written into any proposal. So, unique identifying information beside the name, like their addresses, their social security numbers, their cell phones, none of that's made available to the public under the repeal of 50A. But, these are people who took an oath to protect the public. And when there are allegations of violations to that, that is in the public interest. And I think, the other argument I always make too is, if there is like a one-off complaint that is unfounded and investigated, further, and you really can't find anything, there's nothing that's going to hurt them. But the public policy benefit of hiding all of it, that just doesn't carry the day.
Well, and I'm really glad that you got into that, because the people who are going to be, trying to make this happen in states that still have the secrecy laws, they're going to have to deal with these issues about unfounded, unsubstantiated. First of all, can you explain, at least as you understand it, the difference between an unfounded complaint and an unsubstantiated one? Of course, substantiated means it was, whatever the punishment was, it was found by the department itself. But what is the distinction, and why does it and does it matter? Unsubstantiated, unfounded.
Sure. I think. So just unsubstantiated cases are cases where investigators, and that could be from a civilian agency, an internal affairs division, ultimately determined that more likely than not, the misconduct did not take place. I actually, I'm a former investigator with the CCRB in New York. I investigated police misconduct for 4 years. And so I can tell you that, we were operating on a preponderance of the evidence standard, meaning that, was it more likely than not that this took place? And yet and still, many investigators, even when they believed the claim, they sort of said, oh, well, it's one word against another, so I don't really have enough here to bring me to the preponderance of evidence standard, which I never understood, but that's how they often came down. Unfounded means that you're really just saying that the complaint itself never happened, or that the conduct alleged did not take place. And again, as I stated earlier, when we go back in our wrongful conviction cases and uncover these old complaints, many of which were unsubstantiated and even unfounded, they end up having a lot of merit. So, and they end up being proven. So I think, there are many reasons why it's important to capture this data. I mean, even today, ProPublica put out a piece about how in New York City, NYPD was holding back information from investigators at the CCRB, body cam footage, witness statements, including, or people that were in the cell with the person who made the complaint, just holding it back. Their rationale for holding back body cam footage in one of these cases was that they were protecting the complainant, which was ironic because the only body cam footage they did hand over had the complainant in handcuffs. All of the other body cam footage never saw the light of day, never made it to the investigators. And so that could be another reason why investigators might not substantiate a complaint. It might read as unsubstantiated. And of course, once people are able to dig further, it in fact has a lot of merit. So there's good reason to make sure unsubstantiated and unfounded complaints are part of these laws.
And to drive the point even further, for those reformers out there, I mean, the fact of the matter is that people are often very reluctant to go in to a hearing and testify against a police officer. And then when they do, as you suggested, with the preponderance of the evidence, it's very easy to just simply say, we're not going to believe the civilian, we'll believe the cop. And the point I would like to make, if I may, is to think about, you think about who's doing the investigation. It's the police department for whom the police officer works.
Yes.
And I know we have a lot of lawyers here. Think if somebody alleged that the lawyer that was handling their house closing stole the escrow money, and the place that you had to go to complain was to the law firm for which the lawyer works. I think you can see why it's so critically important to get to these unfounded and unsubstantiated. And if I'm not mistaken, Rebecca, you probably know this better than I do. There have been several of these unfortunate cases where people died at the hands of police, where the police officers actually had a lot of unfounded complaints.
Oh, absolutely. I mean, even, I was Ramarley Graham, New York case. He was killed by, I think, police officer Haste was his name. He had 6 complaints lodged against him in the span of 13 months. None of them were substantiated. So, absolutely. And I think to add on to what you said, right, I mean, there's an obviously inherent conflict in having the police themselves when, internal affairs is looking into these things. But even as investigators, I think back to, when I was 22 years old, right out of college, I was totally ill-equipped to handle investigations of this magnitude. It just was true. I didn't understand a lot about policing. I certainly didn't understand, as communities of color do, what the dynamics are in those communities. And then also our supervisors were retired law enforcement. So there were a lot of pressures on very young investigators who I don't think were equipped to even get the job done a lot of the time. So, I mean, I think a lot of people see the civilian oversight as sort of a panacea. When it comes to this, it can't be seen that way. And that's why, again, we have to make sure all of these complaints, even if they're unfounded, even if they're unsubstantiated, get out of that black box.
So we have a question from one of the viewers, and it's what are your thoughts about the balance between sharing the data with the public and keeping some sensitive data private? Are there some areas, for example, that perhaps don't relate to policing that should be protected?
I think, as I said before, I think there are certain things that you can keep secret, right? Like personal information about medical histories is another great example. Like, obviously if a cop comes in to his supervisor and asks for substance use treatment, that's information that does not need to hit the public. Now, if that same officer is engaged in a DUI, arguably that is information that would, rise to the level. So I think that there are certain areas where you absolutely can put in protections. I mean, I think people are less concerned about whether a cop, didn't shine his shoes under regulation, right? But I think, it's a slippery slope. And I think it's important as you're doing advocacy around this to not go too far down that slippery slope, because then you start seeing cover-ups of information that may not even seem that relevant, but that really is. And so, and then there's a ton of hidden stuff, which is never going to be uncovered. I mean, Julie talked before about, sort of the fact that, law enforcement, gets overtime, right? And that overtime often, has an impact on policing. And, New York City, for instance, in, I guess it was 2014, there was a huge case, a class action against NYPD, that was successful, and it showed over a 7-year period, 900,000 false arrests. And a lot of that was based on an unofficial quota system. And you could imagine that, cops certainly are going to be seeking overtime, right, to make those arrests. So I just think it's really important to, as we make concessions, and obviously every bill you have to negotiate, but to not lose sight of the really important information. And I think it's easy to it's easy to think, oh, well, it was an unfounded complaint, who cares? It matters.
So I have another question coming in, which is right on this point, which is when the New York law was repealed, where did the new law draw the line on keeping anything private?
So it drew the line, again, with respect to things like, where does the cop live? What's his phone number? What's his social security number? I think that it was pretty broad, and I have to review the final language, which is included in your materials. But, there was even debate about things like, sort of infractions of, police policy, like internal police policy. And I think that even made it through, because I think a lot of what people were saying was, when you put all of these pieces together, often it tells a story. Sometimes none of these things by themselves, like whether a cop is chronically late, doesn't tell you much, but then you have that with a couple of unsubstantiated complaints, and you start to think, well, maybe there's a larger story here. So I think, erring on the side of including is very, very good. But I think, obviously, as you're making concessions, the internal disciplinary practices, about, whether you shined your shoes is probably not going to, be your first priority.
So go ahead, Julie.
Yeah, I just wanted to add to Rebecca's point. A couple of years back, we actually got a huge archive of the NYPD disciplinary files. And you'd be surprised how much those little complaints actually do tell a larger story, because what we saw was often officers of color received much harsher punishments for like much minor complaints, whereas larger infractions, almost like, especially if there was a relationship or a history of that family being in the police department or a chief, just disappearing. And so, or being unfounded more frequently. And we used to have interns go and sit on these disciplinary hearings every day, because we couldn't get the official records, but there was this little kind of intervention point where if an officer made it to the point of there was a substantiated complaint against them and they decided to go to an administrative trial, those trials were actually public. And so we would send interns every day to go sit in on those. And it was actually quite shocking which complaints were taken more seriously. And Chicago found when their records were released that even if a white complainant made a complaint against the police, it was more likely to result in punishment, right? And so our interns were seeing the same thing. More officers of color were in there for not reaching kind of quotas or not listening to their supervisors, whereas other more senior officers would be in there for, I'd say, larger abuse, way more excessive force, false arrest, lying, and not receive any punishment. And so it definitely kind of need all of that data to tell this bigger story.
Well, we've got a great question here. This I think I almost would like to invite both of you, because you both have the expertise for this one. This is coming from a passionate crusader for reform out in California. And it's this: how do you envision ensuring that internal bureaucratic rules do not obscure the nature of complaints or misconduct, especially in light of the, quote, bargaining down to charges? Julie, you want to take a shot at that?
I mean, I would say there's definitely a lot of bureaucracy before a complaint even becomes a complaint. If you're talking about the internal police, like IAB process, you know, most of the cases we see even reach the point of like a trial that we could go to were for a lot of reasons. The supervisor didn't like that officer, or that officer wasn't reaching their quota. And so there is a lot that happens to actually make a charge become a formal charge, which is why we chose not to just rely on the police disciplinary data, because it's right, their own data, and that comes with all of that bureaucracy. And so we chose to kind of use all of these other open source data sources, the lawsuits, the news articles, and our own case data to tell that bigger picture, because you're not going to get it from the police.
I think that's right. I would just only add too that, you know, this is the power of the defense community too in making records in some of these cases, right? Because, you know, even if, you know, your case doesn't end up the right way, but, you know, certain things were revealed about that officer during the course of litigating that case. I mean, file a complaint, because it's another avenue. It's another way in. And it is true that bureaucracies are bureaucracies. That said, you know, once a member of the public makes an allegation, that's in the file. So, you know, whether that goes to IAB or whether that internal affairs or whether that goes to civilian oversight agency. So I think, but everybody should be, you know, kind of doing their part to get as much information out there as we can get.
Oh, it's certainly going to take a lot of vigilance to make sure that they don't do an end run around it. So one of the main purposes of our conference and the State Criminal Justice Network that Monica keeps going throughout the year, supporting reformers around the country, is how to make progress happen. So what I'd like to ask Rebecca at this point is, you know, what are the 1, 2, or 3 tips that you would have for people who are working on this particular issue around the country?
Right. Well, I mean, I think fundamental is identifying community-based organizations that have been engaged in police accountability work, often for decades. They are the people who have been out there ringing the bell for these reforms for a long time. And not only should they be centered because they often have very creative solutions to some of the issues that come up, but they should be centered because they were impacted and have a lot to say about it. And they are incredible advocates in terms of keeping the conversation going. If you think about a theory of change model, you know, even when people that are doing work under the dome are making negotiations, it's all the noise from the outside that's bringing that conversation to a more progressive place inside of the State House. So I think really making connections with the community-based organizations engaged in this work is really important. Obviously, the Innocence Project is happy to partner with you all on this. We also are partnering with the wonderful Monica Reed at NACDL on these as well. So, I mean, reach out to us. We would love to work with you. Also on our website, innocenceproject.org, there is, you can sign up and click on Get Involved. It has a number of live campaigns that are going on right now, information about them and ways that you can contact lawmakers. But I think, you know, it's always just critically important to make sure that you're talking to all the other people in this space before you pursue a proposal, because you'll have a ton of unintended consequences if you're not listening to people in different corners of the community. So those are some basic tips, I would say.
Great, Rebecca. Before I want to go back to Julie with another question that's come in, but before I do that, would you be good enough to tick off some of the states where it looks like this is a hot issue, and where some of the participants in the program might be able, if they're not already working on it, to get involved?
Sure. So there is already something has been introduced already in New Jersey and is about to be introduced in Oregon. Those are definitely happening. I should just pull back and say right now we're in special sessions in state houses. The regular sessions are usually begin in January, obviously because of the outcry for these kinds of reforms around police accountability. A lot of state houses are calling for special sessions right now. So discussions are going on in several state houses. Oftentimes lawmakers and we're in conversation in a few states, so do reach out to me directly if you have a question about your particular state. Sometimes lawmakers themselves want to be the people that roll out that reform. And so, you know, sort of out of respect to some of those conversations, I'm not going to say publicly all of the states right now, but New Jersey is active, Oregon is active, conversations are happening around the country. In about I would say 8 states right now during special session. We expect some of those conversations to get bumped because of COVID and budget issues that are going to maybe, take up all the air in the room. But certainly we expect to pursue this in many more states come January. And obviously hearing from you all and knowing about the connections you have in the states, can make a difference. So I think, I certainly can share with you the states where, the secrecy laws it's entirely confidential in those states. And I will send those materials along as a follow-up, listing out all the states where it's entirely confidential, which is 21 states, and then a whole number of other states where it's restricted. So in other words, it's how oftentimes court precedents, sort of end up interpreting right to know laws or public information laws that end up deep sixing this information. So, I mean, there are states that are restrictive, but they actually ultimately kind of have the same endpoint, which is to keep everything confidential. So it's a live issue, and I would say, in probably 35 states, we have to make fixes or wholesale change the law.
Great. Thanks, Rebecca. Julie, one final one for you. And I'm not sure that you'll have the full scope of this, but we're getting questions about how it was that the defenders in New York, primarily legal aid, which built it, got the funding to do this, and what lessons are there for other offices?
That's a good question, to which I actually don't have a great answer for. There was initial funding just for our project, and I actually not to actually build like a system, but just to track police misconduct like in our office, which was really one person need to do it. And then once we started trying to build systems, we were able to get more funding from private donors, actually to like hire developers. So I can't talk that well to a fundraising perspective. And I know our office was a bit different because we were a nonprofit and not necessarily like a government agency. But I think right now there are a ton of private donors who are interested in this work. Right. And NACDL's goal is really to share what legal aid was able to create so that other offices don't have to deal with that headache. And the funding needs is really for a person to manage that system. And we're also hoping to be able to maybe in certain places help out with that. And so I think it will be kind of, appeals to donors for someone to, because we already have kind of this proof of concept and a system, to just get one person to help us run it. And in cases where you can't, starting with intern power, which we relied on a ton, we'll get you to the point where you kind of get that proof of concept, a system running, and maybe make a better appeal.
Well, thanks very much. I mean, I want to amplify that also by saying that our NACDL's objective, we'd like to get it up and running in hopefully as many as 15 offices within the next couple of years. But we're not stopping there. We hope to bring other support to the table. We do know that for the offices that are entirely public entities, there'll be a challenge perhaps in getting funding. The kind of work that Julie was doing in scraping this data and finding it and putting it in, we will need help with that as well. But I'm optimistic, and I was very optimistic to begin with, but my optimism went to a whole other level when 50A was repealed, because I do believe that the groundwork that was laid through the project that Legal Aid had, the database, helped get it in the public consciousness. I mean, the DAs had already seen that it was a problem, that they didn't have the information, the defense did. And I think that perhaps contributed. Of course, the tragedy is what got it over the line, but I think building that foundation is what makes it work. So Julie Ciccolini and Rebecca Brown, thank you so much for sharing your expertise. I know you're going to get a lot of follow-up.